Summit event on the theme CAMA, 1 year on implementation, impact, and challenges. I'll start off with a few housekeeping before I take the introductions. This event will be recorded, so please ensure that your name is spelled correctly, your first name and your second name with your organization if possible. To change this, please click on the participants column in the menu to open the participants window. Then hover over yourself and click on more to rename. Attendee microphones are muted for this event. However, the host will unmute you if you are called upon to speak. Submit your questions using the chat function at the bottom center of the screen. The moderator will then respond to them during the panel session. If you experience any technical issues, please use the chat function and send your message to Ochoche Inalego, who would be taking that, please. So at this point, I would like to take the introductions. I will introduce our panelists. So today we have in our midst Mr. Garba Abubakar, who is the Registrar General of the Corporate Affairs Commission. He holds a law degree from the Ahmadu Bello University, Zaria, and was called to the bar in 1989. He's also a member of the Financial Services Regulation Coordinating Committee, the National Steering Committee on Open Government Partnership, and the Governing Council of the NBA section on business law. I would also welcome Ms. Bisi Adeyemi. She's the MD, DCSL Corporate Services Limited. She is responsible for providing strategic direction to the team, developing the business, and leading board evaluation and other governance engagements. She's passionate about corporate governance and facilitates board-level training on the subject. She's a resource person at the Institute of Directors and anchors a weekly column on corporate governance in Business Day. She's a 1986 law graduate of the Ahmadu Bello University, Zaria, and was called to the Nigerian bar in 1987. She holds an MBA from the Lagos Business School, Pan-Atlantic University. I would also like to welcome another panelist, Ms. Odunloa Longe. She's the co-founder of the Longe Practice, which is a venture law practice where she represents venture builders and their funders. It's a she's also an award winner, and she's recently written a book, she's written a chapter of a book, Increasing the Access to Justice Through Technology in Technology, Innovation and Access to Justice, Dialogues on the Future of Law, which was published by Edinburgh University Press. I would also like to welcome Ms. Ozofu Ugemida. She is a partner in Udo Udoma and Bello Osage's corporate advisory, private equity and mergers. She's a partner in Udo Udoma and Bello Osage's corporate advisory, private equity and mergers and acquisition teams. She is the secretary of the Nigerian Bar Association section on business law. She's also the thematic lead of the National Assembly Business Environment Regulation Working Group. Thank you so much. So at this point, I would like to welcome Mr. Nana Ude, who is a board member of the Nigerian Economic Summit Group, to please give the welcome address. Thank you.
Thank you very much, Ansika. The Registrar General of the Corporate Affairs Commission and other distinguished panelists for this event, Ms. Odunowa Longe and Mrs. Bisi Adeyemi, our session moderator, Mrs. Ozofu Gemudia, and all participants who have joined us for this event. It is my pleasure to welcome you to this pre-summit event of the 27th Nigerian Economic Summit. The annual summit is jointly organized by the Federal Government of Nigeria, represented by the Federal Ministry of Finance, Budget, and National Planning, and the private sector, represented by the Nigerian Economic Summit, NESG. As we know, Nigeria is a nation with the potential for regional and global economic dominance. However, this description of Nigeria has persisted for several years, and despite such optimism, our growth trajectory has not been in tandem with this potential. And it's against this background that the 27th Nigerian Economic Summit Next 27 will convene national and global leaders in government, business, politics, civil society, and the academia to deliberate on the theme, securing our future, the fierce urgency of now. Our country is currently going through turbulent times, and the challenge of securing Nigeria's economic future calls forth a vibrant entrepreneurship ecosystem that can encourage entrepreneurs to turn their ideas into industry. To achieve this, we must be deliberate in creating the right environment for businesses to thrive. This requires, among others, a legal framework that makes it easier to set up and run a company, ensures more appropriate regulation for micro, small, and medium-scale enterprises, enhances transparency and shareholder engagement, aligns the regulation of companies and other business entities with international best practice. The defunct Companies and Allied Matters Act has been in force for about 30 years without any substantial amendment, despite the constant development in the global business landscape. Over time, the law became outdated and presented obstacles to doing business in Nigeria. Therefore, it had to be repealed and replaced with a law that responds to today's realities. So about a year ago, President Muhammadu Buhari signed the Companies and Allied Matters Act, CAMA 2020 into law. It is one of the priority legislations of the National Assembly Business Environment Roundtable, NASBA, which is a partnership between the Nigerian Economic Summit Group and Nigerian Bar Association section of business law to act on legislations that will improve Nigeria's business environment and achieve economic competitiveness. We are grateful to the Corporate Affairs Commission for its bold and decisive approach in the collaborative process that led to the enactment of CAMA 2020, and in particular to my friend, Mr. Garuba Abubakar, the Registrar General, for his leadership in driving it. However, 1 year after its commencement, it is important to convene stakeholders and discuss its implementation, impact, and challenges. We are convinced that such dialogue and feedback will be useful as the Corporate Affairs Commission continues to operationalize the Act, and other stakeholders will also benefit from the information and knowledge that will be shared during this event. I want to reiterate that our MSMEs hold the key to securing our future, and a legislation that not only brings them into the formal system, but also keeps them within the formal system will lead to faster economic growth, job creation, poverty reduction, and global competitiveness. Once again, I welcome you to this event, and I wish to use this opportunity to request everyone to register and participate in the 27th Nigerian Economic Summit, scheduled to hold on October 25th and 26th, 2021. You can simply do so by going to www.nesgroup.org/27. But for this pre-summit event, I look forward to very robust deliberations and productive outcomes in the national interest. And I invite the session moderator, Mrs. Osofu Gemudia, to facilitate the panel discussion. Thank you.
Thank you very much, Mr. Nana. Good day, good afternoon, our panelists and our participants. Thank you very much for sharing your valuable time with us this afternoon. As has already been said, we have a very distinguished panel representing the private sector, the company secretaries who are primary users of the services of the CAC as well as the CAMA, and the regulator and custodian of this act, the Corporate Affairs Commission, represented by Alhaji A.G. Abubakar, sorry. So I'll start by sounding out the private sector, just to get a sense of what our experiences have been in working with the CAMA over the past 1 year. And then I'll ask the RG to comment on the relevant points. So if I may start with Ms. Adeyemi. With your experience in providing company secretariat and corporate governance support to companies for several years under the old CAMA, the CAMA 1990, and now under the CAMA 2020, What has been your experience in providing these services to your clients in the past year? Have there been significant changes?
Thank you very much, Zofo. I would say the experience has been mostly pleasant. Without a doubt, there has been an attempt to streamline the processes, so starting with even notices of meetings, which can now be sent electronically via email. In the past, you had to do the rounds, by sending those hard copies. That also means that you can send your board packs electronically as well. Of course, before the amendments to CAMA, you could do that, but the notices had to be sent, a hard copy, signed for, and all of those. So that has streamlined to a large extent our processes. Also, the fact that the CAMA now recognizes electronic signatures. You don't have to sign documents via wet ink anymore. That's a major achievement. So meaning that we also spared the hassle of ferrying documents back and forth, having directors sign or having shareholders sign resolutions and all of that. You can actually, electronic signatures are acceptable. I think the fact that also filing is now automated, so you can sit in the comfort of your offices and file documents. There's some hiccups here and there. We'll come to that later, but I think to a large extent, you can sit in the comfort of your offices and file returns and then get the certified true copies of those. Searches have also been streamlined. You can actually now then do the searches electronically. So I think a lot of it has been saving us the trouble of physically going to the CAC. With respect to actual operations as well, the exemption of foreign companies that don't require incorporation. In the past, you needed to get the approval of the Council of Ministers as it were, but now you only need approval from the Ministry of Trade, which is the relevant ministry in this regard. Once you've gotten that, then you can file that with the CAC. I think by far the most innovative of all, which has brought significant, reduced our level of stress, is the virtual AGMs, applicable, of course, to private companies. So in the past, we had to, sort of like persuade our clients, that the importance of having AGMs, but when they think about the trauma of, traveling, particularly for those who are foreign entities, coming to Nigeria and all of those, it becomes a bit of a hassle for them. But now, in the comfort of their homes all over the world, they can actually attend those meetings virtually. So I think those are some of the things that have helped us. And putting the AGM together is not a mean feat in terms of the expenses, the time, and the resources that they expend. So I think to a large extent, those are some of the things that we can say have impacted on our processes, and in turn, of course, those of our clients, to make the administration of their companies and their boards a bit more seamless.
Thank you very much for that. I think that really puts us, on the right footing to take this conversation forward. A lot of positives have been highlighted by Ms. Adeyemi, and so I'd like to ask Ms. Longe, who is very close to startups and MSMEs. Most of the advantages and positives that Ms. Adeyemi just highlighted apply to companies generally and private companies. But as you will know, there are lots of incentives in the CAMA for small companies, which we think will capture most of the MSMEs that you tend to interact with. So in your opinion, and from a practical perspective, what has been the impact of the CAMA 2020 on startups and MSMEs?
Thank you very much. I'll take off from some of what Ms. Adeyemi mentioned. And one of it is the electronic signature. That has been a very, very big positive for SMEs, especially even SMEs or entrepreneurs that are not living in Nigeria but want to do business, Nigerians in diaspora that want to do business, that in the past found it difficult to set up a business because they had to sign their CAC forms physically. So the ability to now use digital signatures to start a business has really been a huge positive for the SME sector. Also being able to have one director and a single director and a single shareholder. In the past, SMEs were limited to using a business name if they wanted to be the only one, which doesn't give them any limited liability. You're basically doing your business in your personal capacity. You just have a name. So the ability to be able to start a business now and not be forced to have a nominal shareholder just because you want to have two shareholders is also a big plus for the SMEs. Then the ability to, obviously go on the CAC portal by themselves also is an advantage. There's also the the alternative for company limited by guarantees, being able to use a publication to complete the process if you do not get the AG's consent on time is also an advantage, in the sense that you find social enterprises that were not comfortable with the incorporated trustees structure, but were opting for it just because it was the more available structure, are now able to use the company limited by guarantee, knowing that they can determine the time when the process can finish. So that's been an option we've also explored for some of our clients that are social enterprises. Having an LLP for consulting services and professional services, being able to register an LLP, I think it was 2 weeks ago that the CAC finally opened that up, but being able to have that option to limit your liability as a professional service provider or a consulting service is also a huge plus. So it's been a net positive. There's been some execution challenges, but it's been a net positive that there is a framework that can be relied upon to do business in an easier manner and to start business in an easier manner.
Okay, thank you very much. I noted that you mentioned there have been challenges. Ms. Adeyemi also mentioned that, and I'll bring you back to speak on some of those challenges, because I don't want us to, I want us to create a really balanced picture here. But before we go on to that, I'll just go over to the RG. So RG, I think you've been, right in the middle of things, trying to get, everything that the CAMA 2020 provides out there and available to the market. You've also been, taking the hit for a lot of the hitches along the way. So I'd just like you to start by telling us the CAC's experience in implementing the CAMA 2020 and what role the CAC has played in, just continuing its role of administration of companies, registration and operations through implementation of the CAMA 2020 and your new processes you've had to introduce to make that possible.
Thank you so much. One of our major challenges relates to the restriction on COVID-19 and having to implement this extensive legislation within a defined time frame. We all recall the bill was assented to by Mr. President on the 7th of August. It took about 3 months for the law to be gazetted. The official gazette was finally sent to us from the clerk to the National Assembly in November 2020. We had to come up with regulations to support the implementation of this law. We have to work on our technology because of the extensive nature of the legislation and the new changes introduced. It wouldn't have been possible to begin implementation with the old manual system for most of our processes. So we had to get our vendors to change the application to make it to conform with some of the new requirements as provided in CAMA. We have to come up with regulations that will meet the expectation of stakeholders in line with the new law. All these things combined at a period when virtually the entire world was under lockdown. We had to rebuild our application from the scratch. Thank God it was done at no cost to government. And we have to come up with these regulations. The regulations were exposed to all stakeholders for their input. At the end of the collation, inputs that were considered germane were reflected. The Honorable Minister had to approve that in record time, in less than 1 week. The regulation was approved. And the implementation started on the 3rd of January. You can imagine the time frame between when the official gazette was released and when the implementation started, just barely 2 months. But thank God, we started well. despite all the hitches, I'm sure a lot of us will talk about the challenges. One thing with technology is you don't get it right from the beginning. Other registries that have done similar things, some of them, it took them 4 years to stabilize their systems. We've continued adding on the features of this new application. Only last week, as Longe said, on the 31st precisely of August, we've deployed the system for registration of limited partnerships and limited liability partnerships. One good thing about the new CAMA is it has simplified the procedure for company formation. And the new technology has made it easier for people to register. And we have removed some of the stringent requirements that were hitherto applicable. In the past, to make any change on any company, you have to have 2 directors or a director and secretary to sign. We have created 2 options now. A company could have its own electronic account through which it can make all its filings, or they can use any of our accredited customers. Where a filing is being made that doesn't require a special resolution to be submitted by the company, then you don't need to even submit signatures. All you need to do at the point of filing is to indicate the officer of the company that authorized, that is where the filing is being made by an accredited agent, the officer of the company that authorized you to make this filing on behalf of that company, because the law has clearly stated that the actions of the company can be authenticated either by a director, the secretary, or any authorized officer. In the past, CSE used to insist that you must bring a document that has 2 signatures. In most cases, these signatures were found not to even be genuine. With the electronic system, it's easier to track because that was why we had to insist on the validation of accreditation by our accredited agent so that we'll know the person we are dealing with. If there are issues, we know who to hold responsible. But where the company ought to have its own electronic account, the company has to nominate one of its officers either within or outside the company that will manage that account on its behalf. And any filing made through that account is deemed to have been authorized by the company. A lot has been said about the simplified procedure, the simplified process, some of the stringent requirements that have been removed. We no longer insist on statutory declaration by a legal practitioner, it's optional. Even where a lawyer is involved in the process, he doesn't have to submit that declaration. An officer of the company can make a statement of compliance, and that will suffice for the purpose of registration. We've also talked, Longe has also talked about one-man company. And another thing that is fundamental is the reduction in registration fees. Hitherto, when you are registering a new company, you must pay for certified true copy of documents. That is no longer necessary. You just pay the basic registration fee and we'll issue you your memorandum and articles and your certified extracts. So let me mention certified extract. In the past, we used to issue documents with personal signatures of the directors and secretaries. There were concerns about data privacy. Some of these signatures were being cloned and resubmitted to us for filings by even strangers. So we had to introduce a new system that will protect the personal information of these officers. We no longer issue, except for memorandum and articles that is issued with the signatures of the persons that actually subscribe to the memorandum. Other documents, we issue a certified extract that contains everything about the entity. It tells you about the name, the date of registration, the registration number, the names of the directors and the shareholders, in place of the old CAC2, CAC7 that used to contain the personal signatures of these individuals. And the law has also introduced, giving these officers the option to restrict their addresses from the public register. Where an officer of the company opts to do that, he pays an additional fee, and he has to satisfy the grounds upon which such restriction will be made. He has to prove that he may be in form of danger if his address is published. The whole essence of this is our register is a public register. Any member of the public can access the register upon payment of a fee. So where your personal address is provided, you may be in form of some danger, especially now that we have security challenges. So there are persons that may be concerned that if their personal address is exposed in the public register, they may be under some form of harm. So an individual can apply to restrict his own personal address from the public register. And where that is done, he has to provide a service address in place of that residential address. So these are some of the issues. As I have said, the challenges of COVID, we all know what we went through last year with the various restrictions. It was very difficult for us to operate last year because of the various restrictions the government imposed to curb the spread of COVID-19. We had to close down our offices. We had to restrict customers from visiting our offices. We had to introduce mailing system. I am glad that most of these things have become history. Virtually all the processes are available online. What is now outstanding is alteration of memo and amendment of constitution. Even on those ones, we are doing the final review of the electronic interface that will allow you to do that. The challenge we had has to do with legacy companies that were registered before the new CAMA, because some of the information is not in the database. So we are providing a medium through which the company can resubmit its own memo and they can now alter it. So these are some of the progress we have made. I must say that it has not been easy, but gradually, I think we are making progress. We'll get there very soon. Thank you.
Thank you, sir. Thank you very much. Yes, I think that the quick rollout of the company's regulations and the portal and all that has been done is really commendable. And while we're having teething problems, I think we're certainly better off and on the path of progress from where we were before. Also, in your response, I noted that you actually were able to touch on some issues that people have been posting in the Q&A. So thank you very much for that very exhaustive response. Ms. Adeyemi, back to you. If I may ask, what the experience has been for boards. Personally, I have been at the receiving end of several requests from clients, board to speak to their boards about the CAMA and what directors need to be aware of. So I just want to know, since you interact very closely with boards, what has been their experience? Have they found it easy to embrace the CAMA, get their head around the changes? Has there been a significant adoption of the changes which impact on governance and management of companies?
Thank you, Osofo. And just like you, we've been inundated with requests, to come and explain to them what are the implications, particularly from a governance perspective. And I must say that surprisingly, the reception has been very, very enthusiastic. There has been some effort on the parts of a lot of directors to, first of all, even understand implications to them, to their liabilities, particularly to their responsibilities and all. But from a governance perspective, there's some specific provisions of CAMA which I have found very, very positive, I must say, because, over time we've had to deal with questions from directors that these codes, are they compelling, is not a law, so if there's a requirement, for instance, for us to have independent directors, is not backed by law. And so there've been those arguments over the years. So clearly, CAMA has come to, make this quite clear that this is the law, particularly for public companies. There's a requirement now to have at least 3 independent directors. When we're talking about the challenges, I would, further enunciate on what those challenges are with respect to this particular requirement. But I think it's clear now that it's the law. You can't say it's a nice to have when you're a public company. And we see that there's been a lot of efforts by public companies to comply. So we've had many requests to help recruit independent directors. So without a doubt, that has improved and has the potential to substantially improve governance, because without a doubt, independent directors bring a lot of balance. They bring independence to the board to the extent that they are truly independent. And that's where I will come to when I'm talking about some of the hiccups. They're truly independent, and if they are appointed in a manner that is transparent. There is also the bit about how many directors, how many other directorships somebody who is sitting on the board of a particular company, especially a public company, can have. So multiple directorships. So CAMA has come to clearly say that if you're sitting as a director on the board of a public company, you can't be on the board of more than 5 other public companies. People are taking this very seriously, and there's a requirement also for declaration. So before you accept to sit on a board, you have to declare how many other boards you're sitting on. And whilst it appears to be commonplace, that the separation of the roles of chairman and CEO, I think also because that was a code requirement, some organizations were not fully compliant. But now that is the requirement of the law in CAMA, that you cannot have the same person act as chair and also CEO, particularly of a public company. So like I said, sometimes you have those roles specified in writing as being separate, but in practice, particularly for the owner-managed businesses who have eventually become public, the roles are not quite separated. So I think that to a large extent could define some of those governance provisions, because over time, I have always been of the view that, you can't legislate everything. You can't legislate, for instance, good behavior. So the codes essentially are trying to guide good behavior as far as corporate governance is concerned. I've always held the view that there's certain governance practices that have to be made mandatory, and that's what CAMA has tried to do, with saying that, the roles of the CEO and chairman have to be separate. You need to have more independent directors on the board. You need to be mindful of multiple directorships. So those are some of the far-reaching, I would say, provisions. And the private sector, most of the boards that we deal with, have embraced this with a lot of enthusiasm. So that's what I would say has been the response of many of the boards to particularly the governance provisions.
Thank you very much. That's very helpful. So I'll now ask Ms. Longe again from the MSME perspective. There was a lot of talk when the CAMA was passed that it was going to facilitate the ease of doing business. It was going to reduce the regulatory burden on startups and MSMEs, and it was going to make it possible to bring MSMEs within the corporate net and therefore make it easier for them to raise much needed financing. Has this been the experience of MSMEs in reality? What's your view based on your interactions with them?
Thank you. This is, access to finance has to do with impact, and this is something that can better be, addressed over a long time. So whatever I'm saying now is more anecdotal than actual data, because this has just gone on for a year. But one of the things, so when you think of access to financing or financial inclusion, I like to think of it from a three-pronged process: savings, payments, and credits. A lot of the fintechs are already solving for payments and savings. But credit has always been an issue because of we don't have adequate credit history, and then the informal sector, especially for businesses, you're getting from the informal sector. So access to credit to do their businesses, access to finance to be able to meet a supplier demand. But you see that with the ability to easily set up a business, it is so much easier. You find that a lot of the challenger banks and the tech startups are now beginning to offer business support and are beginning to tell their individual informal businesses that we can help you with the process of, we can guide you in the process of starting a business. So to that extent, the finance you can get, the financing you can get, the loans you can access from being a one-man person, from being an individual informal business to actually having a company set up, the financing thresholds are different. So to that extent, I can say that anecdotally, we see that happening. We see more challenger banks saying, we can help you set up your business, we can give you loans, we can do all of that. So from that aspect, yes, there is increased access to finance. But on the larger aspect of, investor financing, I think that we will see over time. Because that also has to, that is not limited to CAMA alone. It has to do with other incentives as well for investors and for people who are raising funds. But without a doubt, I'm able to affirmatively say, at least in terms of operating capital, in terms of financing to start, just limited financing, there has been an improvement as a direct result of the ease of setting up a business.
Sorry, I was speaking, I was muted. Thank you very much for that. I mean, it's very encouraging to know that there are actually positives for small businesses, because that's really one of the main objectives of the Act. So I'll move on to the RG on a related question. According to the World Bank Ease of Doing Business rankings, Nigeria is currently ranked 131 out of 190. And as you know, this is actually an improvement over our performance, let's say a decade ago. What efforts has the CAC made in the implementation of the CAMA 2020 to ensure that we can do better and even increase our position in the rankings table? As you know, the CAMA was highly publicized as being a tool that would help Nigeria improve its ranking in this respect. So what do you think the CAMA can actually do or is doing to make this a reality?
Okay, thank you for the question. Basically, the World Bank Ease of Doing Business ranking on starting a business deals with three core issues. They look at the cost of registration, the number of processes involved to register, and the timeline for registration. We've talked about the cost. The cost has not changed. In fact, it has come down because unlike before, where at the point of registration, one had to pay for certified true copies. Now you just pay for the basic costs. And the option to register directly, because the significant costs the World Bank was calculating had to do with the fee for legal services. They normally include that. Now that it is clearly provided in our law that you don't have to go through an agent, you can register directly. Where you choose to register directly, you don't need to pay anybody for professional services to register on your behalf. So that element is knocked up. Then the time it takes or the number of processes. The process is fully electronic. Unlike before, where when you submit, you still had to print your documents, get the directors to sign, then you upload these documents again and submit the originals to CAC in exchange for your certificate. That is no longer necessary. You upload your signatures, you fill out your forms electronically, you pay electronically. We have integration with the Federal Revenue Service. You pay your stamp duty. The documents are stamped electronically, and you receive your certificate electronically. So the timeline, we have a service timeline of 24 hours for registration, where all requirements are satisfied. I have mentioned the challenges of COVID. Thank God, with the new system, we've enabled our staff to work from anywhere. We provided them with laptops. Staff even work on weekends. We generate certificates even on weekends now. We don't wait till Monday to Friday to generate certificates. We approve registrations at any time. So this has actually reduced the timeline. So we hope we're sure by the next cycle of the ease of doing business, we'll see a significant leap in our rating, because all these three issues will actually help to further raise our ranking. And what we have done is comparable to what you can get anywhere in the world. And the law, part of the challenge we used to encounter was they would tell you some of the things you included in the regulation is not supported by the law, or this and that. The law has clearly provided for some of these reforms now. So I believe we are going to see a better ranking in the next cycle. And the last cycle coincided with the restriction on COVID. The result is not out yet, but by the subsequent ranking, I'm sure the World Bank will take cognizance of all these initiatives. Usually they test it themselves, the initial registration process to prove that the portal is actually working. And since the beginning of this year, we've not recorded any downtime on our portal. The portal has been up and running from January 3rd when it was deployed to date. So where we have major issues is usability. And we're going to all the states to interact with customers to train them on how to use the application. So this has been ongoing. Our team, they were in Lagos last week, and we are planning a customers forum in Lagos early October to also expose and discuss some of these challenges with customers. So what I will say is, on starting a business, because the ease of doing business is not just about company registration. It covers a lot of issues. But on starting a business, as far as the CAC aspect is concerned, because we have uniform standard across all the states, you can approve from anywhere. Applications are routed to approving officers regardless of their location, and they approve these applications. Somebody in Lagos will approve application emanating from Maiduguri. So we're beginning to see, and we have onboarded non-lawyers to even approve this application. We have trained them. This will further reduce the timeline, because the more people you have approving, the faster the process will be. So I believe we'll just continue to get a better ranking in the future. With what we have done, I believe the next cycle of ranking on starting a business, we should be among the top 10 in the world. That's how optimistic we are. Thank you.
Well, thank you, RG. That is very optimistic. So we'll be keeping our fingers crossed for that. Okay, so having laid the foundation for what the CAMA, has aimed to do and has been able to do in the first year of implementation, I think we're going to turn now to the loopholes or the challenge. I got a question today on an issue that struck me as possibly an oversight in the drafting, and I'm happy to share that later on, but I'll let this panelists speak first on their observations. So let me go back to Ms. Adeyemi. What would you consider as the key loopholes in the CAMA or the gray areas in the CAMA 2020 that need to be addressed for improved implementation?
Thank you very much, Zofo. There are a few of them that one has noted over the period. I think whilst the intention is to reduce compliance requirements, particularly for those companies that have been defined as small companies, there's now a need to align with the other requirements that still exist. So for instance, there's a requirement for a director and a company secretary to execute the annual returns. Those small companies no longer are required to have company secretaries, even though some of us wonder to what extent, apart from cost, how much benefits they will derive from that. So there's a need to sort of look at some of the compliance requirements vis-a-vis the exemptions that have now been granted. Also, the single shareholder company, a lot of people are fascinated by it, and we've had questions around, okay, so I established this company with myself, my children, and my spouse. Now that there's no need, there's now a possibility of having a single shareholder company. How do I convert that company back to a single shareholder? It would be useful to have some guidance in that regard. It would also be useful to have some guidance, like I said, around some of the formatting. But for me, a major loophole, and I think it's actually an error in the legislation, and I would like the RG to, we've had occasions in the past to address this with him, but I would like some formal confirmation as to whether indeed what the intention of the act is. So the requirement of having Section 275 that requires public companies to have at least 3 independent directors, that in itself is not in contention. I mean, I think the more independent directors, a board would have, the better that board will be as far as effectiveness is concerned. But in defining who an independent director is, I think there's a problem with that definition. And if it's left like that, then it provides a lower standard, than what is applicable with the codes and what is applicable even global best practice. So what it says is that it defines an independent director as a director of a company who or whose relative, either separately or together with him or each other during the 2 years preceding the time in question, was not an employee of the company, did not make to or receive from the company payments of more than 20 million, or own more than 30% share or other ownership interest in that entity, or in fact in the entity in which he or she is to be appointed an independent director. 30% is a whole weighted threshold. I mean, that totally removes independence from it. So really, if we do not address that, it might give the wrong impression as to what it really is the qualification of an independent director. And like I said, it provides a much lower standard than that which is expected from the Nigerian Code of Corporate Governance and the other sectoral codes, now guidelines. And in fact, best practice. So those are some of the loopholes that one has identified in the CAMA, and one imagines that it will be important that there's some clarification when an amendment is going to be made, that those areas are considered. Thank you, Sophie.
Thank you very much. Thank you also for bringing up Section 275. That one is certainly one that we've struggled with, and yeah, hoping that it's something that can be addressed in the future. So let me go to Ms. Longe also to talk about loopholes, but in making your comments, I'd like you to also comment on the issue of the threshold for small companies under the CAMA. Now, if you would have observed that the threshold for small companies under the CAMA was increased, the monetary thresholds were increased to reflect the current reality. And so under the CAMA, amongst other qualification criteria, a small company is one whose net assets are no more than 60 million and annual turnover not more than 120 million. And these thresholds were aimed at broadening the net for MSMEs that qualify as small companies so that they benefit from the lighter regulatory compliance requirements accorded to small companies under the CAMA. Interestingly, the Companies Regulations 2021 seems to have reversed that by stating that the threshold for small companies, the turnover threshold, is as prescribed by the Finance Act. Currently, the Finance Act threshold is much lower, 25 million. So what that means essentially is that the larger threshold in the CAMA are of no effect if the CAC is not going to recognize them and accord the relevant benefits to the companies that otherwise would have complied. So what do you make of the effect of this on MSMEs, and then any other challenges that you've observed with the provisions or the implementation of the CAMA in relation to its impact on small companies, small and medium-sized companies?
Thank you very much. I will start with the issue you specified before I go into other implementation issues. Like you rightly explained in your question, that the company's regulation now subjects the threshold of a small company to the Finance Act. But in law, we do know that a subsidiary legislation cannot effectively amend the parent legislation. So it is arguable that there is still a conflict. A conflict still exists as to whether you're a small company under CAMA or rather I'm recognized as a small company in CAMA and I'm recognized as a small company with the FIRS under the Finance Act. So saying that there's that error, I think the error needs to be addressed by legislation because that confusion will continue to exist. The regulation, we know that the regulation seeks to correct it, but we also know ourselves as lawyers that anyone can take advantage of that loophole and argue that the regulation is not able to correct the law, and then it becomes, a court case. So I just think that should be addressed by regulation, by legislation, so that it is consistent across board, and you're not confused whether you're a small company under the FIRS or you're a small company under the CAC. With regards to implementation, I was happy when the RG said that ease of starting business is different from ease of doing business. Because whilst I can, attest to the fact that ease of starting a business is much simpler, post-incorporation has been quite challenging. Now, there's quite a number of issues that the new CAMA seeks to address. So for instance, you have to allot all your shares. And there's a deadline for when existing companies should allot all their existing shares. Now, for post-incorporation for existing companies has really been a challenging, it's been really challenging. So many small businesses, and not just small businesses, people misplace things, people don't have complete records. And so some clients don't have everything, and you need to do research to be able to know how to address these things, those new provisions in new CAMA. But the price of searches has gone up. for you to, if you do the 5,000 or 10,000 naira search, you don't get much information. You only get what was there at incorporation. So you don't know your complete state. And then you ask a small business to bring 50,000 is the statutory fee to do a search, and it also takes a long time for that search results to come out. So that's been a bit challenging, that compliance for the existing companies, the legacy companies, to be able to comply with the provisions, because we need to do these searches first so that we know what it is that needs to be rectified and what it is that needs to be changed. So it would be a good thing if there's an in-between search parameter that at least till this compliance period is over, till December, where there's a deadline for companies to comply with the provisions of CAMA 2020. Also, in terms of incorporation, I think this has more to do with being up to date with regulations, the CAC employees being up to date. I think there's an implementation part. Most of my points will be made with examples, practical examples, and my examples are examples that have happened over and over again. So I'll give an example of the SEC recently released a new license for digital sub-brokers, which is targeted at many startups and small startups. The share capital, the minimum share capital for that is 10 million, and we attempted to register one for clients, but it kept getting queried that to be a broker, you need to have 300 million minimum share capital. We attached to the SEC regulation and it wasn't addressed. So it's until you'll be able to call somebody that knew somebody. So I think things like this is challenges. Even when it's a challenge for a lawyer, you can imagine someone who's trying to do this by themselves. So I think it is important that we also have the people who are doing this be up to date with other regulations, be open to submitted documents, because we did submit the regulation from SEC and it still wasn't addressed, and go the extra mile to make this process easy. Same with the one shareholder, one director thing. When it's a foreign owned company, we've had instances where it was okay for the foreign owned company to be one shareholder, one director, and we've had instances where it was queried that because it's a foreign owned company, it is supposed to be two directors. So there's no consistency in implementation. And you really then don't know what to tell a small business, that this is what the law says, but I don't know what will happen when I put it up in the portal. So, some of these challenges, there's need for consistency in implementation. There's need for consistency. There's need for an awareness of what other regulations, the change in regulations, the CBN and the SEC continue to bring out new regulations, new thresholds. So as against, being open and updating those on time will also go a long way. Another challenge, and I see that someone actually asked that in the Q&A, is when incorporating a company, it's not clear anymore. In the past, you could, when incorporating a company, you could set up, you could have preference shares and ordinary shares. And now, whilst the portal allows you to do that, it keeps coming back. You can't submit. We've had that experience, where then they had to do it as a post-incorporation. So implementation has been challenging for post-incorporation, but setting up a business, I can attest to the fact that it's been a vast improvement from what existed in the past.
Thank you very much. All very good to hear. So I'm going now to the RG.
Yes.
Okay. Yes. Yes, sir. So maybe your responses to some of the issues that have been raised in relation to loopholes, and then maybe other things you have observed. And then while we have you speaking, the one major issue of concern that came up when the CAMA was passed was the new role of the CAC to investigate the affairs of incorporated trustees where the interest of members of the public demands. As you know, there was a lot of press on this, and people alleging that this could mean that the CAC would interfere with religious freedoms and the operation of houses of worship. So can you tell us, for 1 year on, what has been the impact of this rule in relation to the thorny issue on the regulation of NGOs in Nigeria, and including religious organizations? And then, of course, your own experience with other loopholes or issues or gray areas with the CAMA.
Okay, in order not to lose track of some of the issues raised, I will start with those issues. First, with the issue of independent directors, definition of independent directors. That is actually a major loophole, and we have noted that the standard should not be lower than what obtains globally. So it's one area of amendment that we are looking at. I don't know when we'll start the process, but thank God we have NASBA with us. The process will be easier with NESG and the NASBA team, but I want to assure all our stakeholders that this is one area that we are looking at, and as soon as it is practically possible, we'll start the process, not just on that one, on other provisions that may have one or two issues. On the issues raised by Ms. Longe, the challenges of searches and other things, there is another window of conducting searches, and that attracts a fee of only 1,000. If you recall, we have issued different press releases advising customers that apply to update the record of your company. Send an email to spu@cac.gov.ng. They will update the information, because we all knew the situation before January this year. The process of filing of all post-incorporation applications was totally manual. And there was no system in place then to update the database as those filings were made. We have a database that was not a true reflection of the state of affairs of most of these companies. When we were migrating to the new system in January this year, we had difficulty in how to approach it. The one issue was whether to start from the scratch and just move the names of these companies, their RC number, and date of registration, and ask every company to resubmit afresh. Or you move the data you had before the cut over, and now request companies to request for update. When they request for update, we'll pull out the file and now update the information. We opted for the second option because if you are asking companies to start from the scratch, we didn't have any assurance that the right people will come forward and do this thing. You may have strangers sending requests in respect of companies they don't have any interest in. And there may be a problem because some may try to hijack a company that doesn't belong to them. And there was no way to ensure that what will be submitted will actually be correct. So we now issue this advisory to all stakeholders that send an email. Don't wait until you have a transaction with the CAC. If you are a company secretary to different companies, send the list of these companies. We'll pull out the files and update up to the last manual filing that was made. Immediately it is updated, and we have a view-only search on the public search. It gives you information about the entity just for 1,000 naira. It gives you the names of the directors. So if after conducting that search, you are not satisfied with the information, then you send a request to SPU to update. Once they update, you will see everything. We had to introduce different categories of searches. Historical search, those ones are conducted manually. Then we have the due diligence search. We were very reluctant to even introduce the due diligence search by customers because we don't want customers to handle our documents. We have had terrible experiences in the past where our documents were filtered, files were even removed from our premises. So to get against that, we now started conducting these searches on behalf of customers. But it was even SBL that gave us the advice that do due diligence and introduce historical search for customers that want it. But you can still have the report you want after it is updated. Once it is updated, then you can have a seamless process of filing for all your applications. Because what do you need to update? You need to update the directors up to date, the shareholding, the address, and everything. So once that is done, then the information moving forward will be correct. So I will advise, if you have clients that have not been updated, please send a request to spu@cac.gov.ng. These files will be updated. Once they are updated, you won't have any hitch in your post-incorporation filing. Then the issue of turnover threshold, and net asset threshold. There is no conflict, and there is no subsidiary legislation that is bypassing the main law. What the law says is the threshold is 120 million for turnover and 60 million for net asset, or such other amount as may be prescribed by regulation by CAC. So the fact that we have prescribed a lower amount, we've not contravened any law. And in doing that, there is need for uniformity in our laws. Finance Act cannot be saying one thing and CAMA saying another thing. Initially, we even wanted a lower figure of 10 million and 5 million, but we finally settled for the provision of the Finance Act. And the turnover and the net asset is not the only determinant. The law says a small company must be owned fully by Nigerians, and the directors among themselves must hold at least 50% of the shares. And there shouldn't be any government participation in that company. So that brings me to the issue of whether a company with foreign participation can have one director or one shareholder. It can have one shareholder, but it cannot have one director, because any company with foreign participation is no longer a small company. The requirement to have one director only applies to a small company. Any company with foreign participation, is not a small company within the provision of the law. So they must have, whereas they can have one shareholder, they must have at least 2 directors for as long as a foreigner is involved in that company. And on complaints, you don't need to know anybody to send a complaint. We have a support center now on the portal. You don't need to have an account to send a complaint on the support center. And you get a ticket, you can even track your ticket off to resolution. So we have made it easier. You don't need to know me, you don't need to know anybody. And I have taken note of the concern about the share capital threshold for some of the capital market operators. We have the SEC regulation, we update it every day. I believe the person that queried that, maybe he wasn't aware of the update, but I've taken the feedback and will ensure that moving forward, whatever we have is up to date. There was no reason to have queried that application at all. We have all the guidelines from the CBN, but sometimes some of you try to couch your memo in a very wide manner that may suggest another thing. So some try to be very clever, thinking that we may not spot that they may be trying to do it, to use it for another thing. So if you make it so wide as to suggest other activities outside what is prescribed by the SEC regulations, I'm sure we'll pick it up and it will be queried. So try and limit it within the confine of what the SEC regulation provides. Then on the issue raised by, you may have to remind me, Mrs. Osofo, on that question.
Is it the one on the incorporated trustees?
Yes, sorry, yeah. So on incorporated trustees, yes. Well, the controversy has died down. CAC will not take over any religious institution, but the law has given us the power to suspend trustees, and where it becomes necessary to do that, we'll not shy away from doing that. The power to investigate is necessary because, in the first instance, these organizations are not for profit. They are supposed to operate in line with their enabling constitution. And for us to register any association under incorporated trustee, the constitution must have provided that the income and property of that association will be applied strictly to pursue the objects, and no portion of that income will be distributed by the trustees or by the members. So anybody that subscribes to that must operate within the confine of the constitution. If there are grounds to believe that these monies are being misappropriated, then CAC will investigate. And where, after the investigation, if it is established that there are infractions, then the law will take its course. So this is necessary because we have, if the law has given CAC the power to investigate companies that are even profit-making organizations, that are supposed to give profit, shared profit to the members, where you have shareholders that invested, what more of incorporated trustees, where the members are not shareholders? Their only stake is the money they are donating should be utilized to pursue the objective of that association. So I believe the law is trying to protect these monies because it's not supposed to be utilized by the trustees for their own ends. It's supposed to be applied to pursue the objectives of the association. We've not had any instance to commence such investigation yet, but I'm sure very soon we'll have some grounds to do this investigation. I will make it public anytime we have such. We want to have a test case, so I will test the provisions of this law, and the public will know that it's not business as usual. Thank you so much.
Thank you very much, RG. There are loads of questions for you on the Q&A, and I'll definitely be coming back. But if I may go back to Ms. Longe, I believe. Yes, because Mr. Adeyemi had commented when she was speaking on one of, responding to one of the questions, she'd commented on the fact that other than cost, she didn't really see the benefit of a company not having a company secretary. So I wanted to ask you, since you provide advice to startups, considering the ease of registration of businesses and individuals under the CAMA 2020 and the CAC's e-portal and all the things we've talked about today that make it easier now to comply with filing requirements, etc. under the CAMA, how important is the role for lawyers going forward in relation to supporting clients, supporting companies with their regulatory compliance matters under the CAMA?
Thank you. I still think that, I can actually authoritatively say that lawyers are still very essential to this process. I think people should be able to start businesses easily. So I am happy, I like that people can go by themselves to start their business. However, you still need the guidance of lawyers. You need the advice, how to couch your object, for instance, like the RG rightly said. Some people will, how it comes in their head is how they put in the objects for the MEMATs, and it's not in legal language. So you still need the guidance of lawyers in capturing your objects correctly, in capturing what you actually want to do so that you don't fall, especially if what you're doing does not fall under the purview of regulation, but you have couched your object in such a way that you need to have a certain share capital. So lawyers still come in then. But if you're starting in a simple business, if you're starting, something that does not require necessarily require legal support, then it is a good thing that the CAC allows individuals and entrepreneurs and people who want to set up a business do so by themselves. But I don't think it in any way reduces the relevance or functionality of lawyers. I think whatever that is routine, we should let technology do that. That's why we have technology. The 5 years lawyers spend in law school and 1 year in university and 1 year of law school is not to come and dot I's and cross T's and just do routine work. It's to do proper advisory work. So I think it's okay to let technology do those things that are routine and let people do them by themselves. And then we as lawyers can provide the advisory, can provide structuring, and for the bigger companies, provide company secretarial as well. When they start off, they might not have a lot of, they don't need to have all the meetings, they might not need to incur the cost. But when you begin to grow, there's a certain stage, like I said, we work with small businesses. We let them know when it's right for you to start having all these things in place, when it's good corporate governance. The minute you start receiving investors' money, then it's only right for you to implement good corporate governance practices, like having a lawyer act as your company secretary.
Thank you very much. So with that, I would like to begin taking some of the questions in the Q&A tab, because there are quite a few. Most of them I am going to direct at the RG because it seems like he's best suited to address them. But let me start with one of mine, RG. No, it's not mine. Someone asked me yesterday. Yes. Okay. So the process for the share capital structure now, where we don't have authorized, and when you issue new shares, you've effectively increased your share capital because your issued has increased. So the question was that in practice, the CAC process is that you file an increase of your issued, and the CAC will process that, and then after it has been processed, you go and issue those shares. So it's like a two-step process, which doesn't seem different from what we're doing before.
Okay, we're actually working on consolidating the two. so that
Okay, sir.
when you are filing, it comes with the allotment and it's registered at once. Once the increase is filed, then the allotment is automatically reflected.
Okay,
So
thank you, sir.
That will entail a tweak to the technology, but we're working on that actually. That interface is being built. Yes, it's easier for everybody.
Okay, so let me now go to the Q&A. The first question is, how do we allay the fears of clients on the security of their electronic signatures? And I'll direct that to the RG.
What of the manual signatures that they were collecting before? What is the difference? We've had this concern from some quarters that customers are reluctant to just sign on a piece of paper and give to a lawyer. So the option is the customer can register himself. And this signature is only required at the point of registration of a new entity. In fact, we had contemplated even on the necessity of even collecting the signatures. Because other registries like the UK, even though the law says consent has to be given by a director to act, they don't insist on you signing. The person registering will now indicate whether such consent has been obtained. On the strength of that, then they will go ahead and register. But we'll come back to our stakeholders to debate this, provided the person doing the registration will take responsibility where such consent is not actually obtained, but he uses the name of somebody without obtaining his consent, then he takes responsibility for that. But you are simply uploading. When you upload, when you scan and upload the signature, then that will suffice. It's stored in our database. And nobody can see those signatures, unlike before, where customers can even obtain certified copies of documents with the signatures on them. So I don't see any difference. In fact, this one is even more secure than the old system, because we had instances where certified copies were obtained, these signatures were cloned, new documents were submitted to us to make changes to these companies. It's no longer possible, because with the new portal, as I have mentioned, you are either filing as an accredited customer or through the company electronic and entity electronic account. And for certain transactions like change of directors, change of address, increase in share capital, you don't even need signatures. It's only when a special resolution is required to be submitted to support the filing. That's when you have to you have to upload a special resolution at post-incorporation level. And the signatures required is usually at pre-incorporation stage, because the law says a director must give his consent, and the memorandum and articles, you have to subscribe to the shares and you have to sign the articles and the memo. So it's only in such situations that we actually ask for signatures. So the assurance I want to give everybody is our data is secured. We don't have any instance, but what we have is even better than what we had before under the manual system, where customers were signing these documents and the lawyers were scanning them, uploading it, and we still certify these documents with signatures. The only document that contains signatures now that is issued by CAC is the memorandum and articles or the Constitution. Other documents, we only give you certified extract. So there is no reason to fear anything. The privacy of their data is still respected, and nobody will just go and hack into this. If their clients are not comfortable giving them signing documents in that manner, you can still do a consent sheet for him to sign. Then you crop the signature and upload it. Then you keep the original copy of that consent in your file. So that's the way to allay their fears. Or you make it open to them that, look, this is what that is the position now. But as I have said, we are coming back to you, to SBL and other stakeholders, to debate the necessity of even collecting the signatures moving forward. With the electronic system, a signature is necessary. Where any filing is being made through a recognized username and password, I think that will suffice. If a lawyer is registering on behalf of a third party, the lawyer has to make sure that he has the right authority to do this registration. We may not even insist on collecting the signatures or submitting such signatures to CAC. Thank you.
Thank you, sir. Okay, so the next question again for you was asked by Buni Uduba, who says, please can you provide a reason why we are to download our documents on the CAC portal within 7 days of completion of registration and thereafter have to pay 5,000 for downloading after 7 days?
Thank you so much. The portal is not a storage place for customers. You have the option to move this document to your device or you print it. So why should you keep it? It slows down the application. It makes it heavier. If you keep it till after 7 days, then you have to pay because we are storing for you. You are paying demurrage because we pay money. It increases the size of our database and it also costs us money. When you get your results, save it on your own device or forward it to your clients or print it. If you leave it on the dashboard, it will leave the dashboard after 7 days. And you have to pay again because that will be a CTC request, more or less like a CTC request. So I don't see any problem with that. If you have your own, except if you are using a business center and you are relying on the business center to store your documents like some of us are doing. If you have your own device, or you can forward it to your email. You can print it at any time. But if you leave it on the dashboard, it actually slows down our application because it overloads the system. So that's the whole essence of this decision. It's not to punish anybody. You can have an external hard drive to be saving these documents if your device doesn't have the necessary storage. So I think we should learn to do the right thing. Thank you.
Thank you, sir. Under the new CAMA regulations, can an officer of the company not be allowed to carry out unnecessary registration and applications directly online instead of going through accredited agents? I mean, I think that's the case, but please, RJ, if you could clarify.
Well, there are two options. We have said this. You cannot talk about ease of doing business and use your own standards to measure the ease of doing business. There are globally accepted standards. Globally, owners of businesses or promoters have the right to approach the registry to register their own entities. And after registration, they can do their registration themselves. A lot of companies have in-house secretarial services. Some are even lawyers. Why can't they do their own filing themselves? The role of lawyers, as somebody has said, registration of companies is not really a legal job. The advisory services, insolvency practice, these are the real legal issues. Anybody can register a company. It's just to complete the forms. Once you can complete those forms right, and most of us that even say we register, we go to business centers. They do copy and paste. Sometimes we don't even read these articles. We don't read this memo. We still accept them as our own products. When CAC queries it, we begin to run helter-skelter to correct. So we've given the option, similar to what obtains a new registration. The best practice is a company can have its entity electronic account, and they can make their own filings. But we know the new CAMA has made the process more technical. Some of the disclosure requirements are more extensive and more technical. You certainly need a lawyer. A lot of people don't even know what personal significant control means. The requirements of filing of annual returns, you need somebody who is very knowledgeable to do it for you. So even when the law says you can do it yourself, in most cases, even now, over 90% of these applications are still being filed by lawyers. But for you to satisfy the World Bank and the world that you have the enabling environment for ease of doing business, you must operate in line with best practice. And the best practice is the use of accredited customers or lawyers is optional. If a customer chooses to go through a lawyer, that's his own choice. If he chooses to do it directly, that's his own choice. So I don't think lawyers should have anything to worry. Instead, lawyers should focus on improving their own knowledge on insolvency and other areas of practice. After the company is formed, they will need legal advice in most of their dealers. When they are entering into an agreement, they will need legal advice. When they are doing tenancy or land agreement, they will need legal advice. They will need a lawyer to draft these agreements for them. So we shouldn't bother ourselves with all these briefs that fetches us 10,000, 20,000, 30,000. I think we should aim higher and remove the glass ceiling and begin to think like lawyers that can make $1 billion on a transaction. That should be our focus. Thank you.
Thank you, sir. There are a few questions just talking about delays with applications, and I just think maybe we'll just take that as one blanket question and it will deal with some of the concerns. Also questions about maybe not getting responsive or responses as required from the backend support at the CAC. So if maybe, sir, if you could just address that with one response.
Okay, thank you. Delays. What we have done since the deployment of the new portal, every post-incorporation application submitted, we don't query it if it appears okay on the face of it. We don't even pull out the file to even check. We rely on what the customer is submitting, and we approve these applications. And as I have said, we have enabled our staff to work from anywhere. So I don't know where the area of delay is. Is it on annual returns? Is it on charge of directors? Is it on increase of share capital? I have also mentioned that there are a few processes that are still manually done. Things like alteration of memo and amendment of constitution. We are working on the technology. Hopefully within the next 2 weeks, we'll have the interface for you to do it electronically. There have been a lot of improvements, and you can't even compare it with the situation we had last year with the challenges of COVID. This system is still new. There are a few bugs and glitches, but these things, every day we improve on the system. We do review every day. Yesterday I was in Lagos. I came back around 6. I had to be part of the review till around 10 p.m. yesterday. So we review every week. We do review. We reviewed state of development. We review some of the features on the application to make it more user-friendly. So we are not resting on ours. I can assure our customers. We started this in January. We are only in September, and you can see the improvements. By the end of the year, most of these glitches will have been addressed. And we also recognize that because we have introduced non-lawyers in the approval process, some of them may not be proficient like our lawyers. So we are training them and retraining them so that they will know these requirements, and it will make the process faster. So the delays will be history very soon. And on the part of customers, I will just appeal to you, before you submit any documents, please ensure that it has satisfied our requirements. If you submit documents that are not consistent with our guidelines and requirements, to be queried. So try and minimize such instances so that your application will be treated expeditiously. A lot of us before now used to have our CAC Connect. When we have any application, we call somebody in CAC, he follows the file from table to table. That window is closed. A lot of us are not happy because the guy that you are calling, if we catch him doing that, the next thing he will send him out of the system. We want to treat our customers fairly and equitably. We treat our application on first come, first serve. We don't prioritize. If you want prioritization, then pay for same day. So the support center is about 2 months old and is working. Customers are actually getting results on the support center. If there is any application that has not been treated and you are not getting feedback from the support center, use other available channels to escalate your complaints. We have email addresses. I must admit, our call center operates from 9 a.m. to 4 p.m. It's not 24 hours. We only have helpline. We are working on a robust customer relations management system that will run 24 hours, and that will be effective from next year. Because we have to do the procurement process so that we'll have the lines and email, and they will be able to interact with customers on a real-time basis to get these complaints resolved. So our customers should be patient. If you see the improvement from last year to date, you know that it's not a joke. We are very serious in the discharge of our responsibilities, and we are doing everything possible to make life easier for you. At least you should be happy that Today, you don't need to come to CS. You don't need to print your certificate. You don't need to wait for a courier company to deliver your certificate, or you don't need to come to CSE to pick your certificate. From the comfort of your home, you can initiate and conclude your registration and get your results without leaving your office or your house. So this is an improvement. We want to make this registry at par with some of the best registries in the world, and we're serious about this. Thank you.
Thank you, sir. The next question is, there's a question about, whether it's obtaining CTCs of statutory forms can be reinstated, because sometimes the certified extracts don't have all the information and so don't satisfy all the needs. And because the CSE has the statutory forms, they have all the information. So is it going to be possible to request CTCs of forms if you are not satisfied with the certified extracts?
I don't know where we will get these forms, because it's electronic submission.
Mm-hmm.
You just fill out the form and you submit. What the report we generate is actually the output from these forms. So you don't sign forms again. As I have said, when you do any post-incorporation, we don't even require signatures. It's only when you are required to submit a a special resolution that you're actually required to upload this special resolution. So all those forms, you just fill them online. We don't generate them in the manner we used to do before. The old system, it was possible in the old system because after you have submitted, you still have to download the form, print it, get the directors to sign, then you scan and upload again. That is not the system any longer. We are moving to a registry where all these things will not be necessary. All this information. And if you are, what information do you require? In a company, you want to know who the directors are. You want to know the shareholders. You want to know the address. You want to know whether it has encumbrances. What else? What else? If you want the financial statement, we are working to make it possible. We are getting support from the EU to build an electronic platform for submission of financial statements. And it could be in extensible reporting language. So that will make it possible for you to submit your accounts in raw form or in PDF. So once that is completed, you can actually obtain certified copies of the account. But for annual returns, what is there that you want to certify? Because it's the same information about the company that you actually rent. So I think we need to change our mindset. Until we change our mindset to begin to query ourselves, why do I actually require from CS? What information do I need? We should attach value to the information, not to the form in which we get this information. So for as long as the report is all encompassing, I think that should be sufficient. Thank you.
Thank you, sir. Also, you had mentioned earlier the issue of manual amendments to MEMAT and constitutions and how that was going to be resolved. There's a question about the status of pending manual filing of annual returns.
I don't think, we've advised customers, we gave a window of March or April this year. And all the manual processes that were pending up to that date had been cleared. So if anybody has any annual return that is outstanding, I'm sure it has been queried, maybe it's still with the courier company and he has failed to go and collect it. So what we will do is we'll publish the list of all those queried applications on our website within the next 1 week. And we'll indicate the courier company that has the document. So customers can approach these courier companies to collect their documents. If it has been treated, we normally send the acknowledgement copy to the email address of the customer. Some of us don't open our emails, especially when we see a strange email address that we do not know, because we've started sending bulk email to customers. About 3-4 weeks ago, we sent about emails to about 25,000 different email addresses of customers. By the next day, only about 500 out of 25,000 had actually opened the email. So I don't know what better ways we can use to communicate to customers. So check your email. If it is not there, then It's possible the application has been queried. And as I've said, within the next 1 week, all those pending applications that had been queried before will publish it. If you had already paid for the annual return, I'm afraid you may have to ask for a refund and file online and pay again. We'll refund you less administrative charges. We'll refund you what you had paid before, less administrative charges of 5% or thereabout. So, but I will advise, if you have not gotten your acknowledgement letter through your email, it's possible your annual return has been queried. Check with the designated courier company, because customers have the option to indicate the courier company that they want their documents to be sent through. So check with them. If it is not there, when we publish the list, then it will be clear from that list whether your own is affected. If it is not, then send a complaint to support center. Thank you.
Thank you, sir. Someone has asked whether it's possible to migrate from a business name to an LP or LLP rather than commencing a new registration. So if you have a business name and you decide, well, I don't want to be a company, but I want to take advantage of the LP or LLP structure, can you migrate, or do you have to kind of abandon your business name and then start a fresh business under the LLP and LP structure?
What the law says is you can register the same name as LP or LLP with the consent of the owner of the business name. So if you have a business name, let's say AG Abubakar & Co. as a law practice, and I want to register an LP, I can apply to reserve the same name, AG Abubakar LP, as an LP, but to do that, I must upload the consent letter and the evidence of registration of AG Abubakar & Co. In fact, this was one of the issues that was discussed yesterday. We've asked the vendors, to do that, you will need to pass through the reservation code. We've asked them to link the reservation code to allow for this. That interface may not be available immediately, may not be available now, but I think within the next 2-3 days, it should be available. So after the registration of the LP, you have the option either to apply to cancel the business name if you don't want the two to coexist. It's like a case of the same name and a business name being registered as a company. The law says you can register the same name as a company with the consent of the owner. Sorry, you can a company can register a business name with the consent of the owner of the company. Oh, how did I mix it? You can register the same name, identical name of a business name as a company, because in most cases, no, you can register the same name of a business name as a company, but you cannot register exactly the same name of a company as a business name, except where that company is in the process of being wound up, either as a business name or as a company itself. But you can register the same name of a business name, or the same name of a company, the same name of a business name as a company, with the consent of the owner of that business name. So all you need to do is to upload a copy of the consent, and we have to establish that the business name is duly registered. So the same thing applies to LP and LLP. If you have a business name and you want to register the same, there's nothing like migration, there's nothing like conversion. It's not an issue of, because there are different entity types. The legal framework for registration of business name is different from the legal framework for registration of limited partnership, and it's different from the legal framework for registration of limited liability partnership. It's not like the case of a company converting to a public or vice versa, private company converting to a public or vice versa. So in the case of a business name, the two can coexist. But if you want the business name to close, then you have to file for the name to be canceled. You have to follow the process of cessation as provided in the company registration portal, and that will cease. But it's safer to get the name registered first as LLP, as LP or LLP. Then after the registration, you can now apply for cessation, because if you do not do that, if you cancel and somebody picks the name, then you'll be at the receiving end. I hope that is clear enough.
Yes. Thank you, sir. Please, before we go on, there have been a few requests. You know, you mentioned an email address that people could send issues to, but I think many people didn't get a note of it. So if you could restate what that address is.
Yes, SPU. S for Solomon, P for Peter, U for Union, spu@cac.gov.ng.
Okay, thank you. I
Just
hope
send
everyone
them.
got that. Thank you.
Yes, thank you.
Thank you, sir. You also mentioned customer fora that the CAC is holding. I know, I mean, you mentioned one early in October for Lagos, which is certainly of interest. So I don't know if how people can get information so they're able to take advantage of these forums. The CAC holds it across the country. How will we know?
Thank you so much. We normally liaise with the local bar, and in the case of Lagos, the collaboration will be with SBL. We are planning to hold 2 different sessions in Lagos, one in the island, and the second one in the mainland. We had wanted to use Sheraton Hotel, but the proposed dates, I think we're looking at 14th and 15th or thereabout of October, just before the NBA conference. For the island, it will be held at the Southern Sun Hotel in Ikoyi. I think it's more accessible to people living in Lekki and VI. So for the island, for the mainland, we are looking at either Protea or Radisson. When we have a confirmed date, it will be available for the 2 places. We are looking at 200 participants each, and it will strictly be on the basis of first come, first serve. So a registration platform will be set up in collaboration with the SBL. Those interested will be required to register. After we've gotten the first 200 for Ireland, it will close. Then for mainland, also 200. We'll come with our technical team. We normally have on the spot resolution of issues, and we try to put customers through some of the areas they have challenges with. And we do demonstrate the live application, so our customer will see how to navigate. Only last week, we conducted some training in Lagos in our offices for selected lawyers. They were invited by the office. They were put through how to use this application. I think about 50 participants in the mainland and 50 also in the island were trained. So during the customers forum, we intend to do the same thing. We've held a customers forum in Port Harcourt. We've held one in Kano. The training is ongoing all over the country. We are holding one. I think we did one in Kaduna. We've done another one in Kano. We're in Port Harcourt. Apart from the customers forum, we've held this training for customers. So I think the collaboration with other organizations like SBL will also help. We'll also be at the NBA conference. We'll have a stand. Anybody that has any issue, we'll have our team to resolve some of these issues. If you have problem navigating on the portal, we'll help you to take you through some of these issues. And we believe with time, people are becoming more knowledgeable on how to use the portal. And very soon, we won't be having these challenges again. Thank you.
Thank you, sir. Okay, before I come back to the RG, just to let you have a little break. There have been some questions on the Q&A chat about people saying that they make findings at CAC and then they find later that the information has not been updated, doesn't reflect changes, resignations from the board, or death of a director, things like that. So I just want to come back to Ms. Adeyemi and ask, is this something you've encountered in your practical experience, or is it an issue of the customer not knowing how well to use the portal?
Thank you very much, Joseph. I think it's a practical problem, and indeed we have experienced it. So what I think has happened, like the RG mentioned, there's been an attempt to upload information, from way back when the companies were incorporated, but I'm not sure this has been done as quickly as one would have expected. I mean, I know there's a whole backlog, and it's going to take a bit of time. I also know that the RG said companies are being called forward, to come and do this updating and to check their records. But assuming that I'm a bank, and I want to do the due diligence on a would-be borrower, it's unlikely that I will have them go and do that updating themselves. I would rely on the search that I or my legal practitioner would do. So yes, we do find out that sometimes you do a search and it doesn't give you correct information. There have been filings over a period of time, and what you get would probably be maybe the most recent according to CAC's records, which really is not always the case. So I think there's a need to to hasten that process, to be sure that when you actually do a search, you get the most accurate and up-to-date record of that entity. Otherwise, there are concerns around the validity of such searches and the accuracy from a record perspective. So yes, indeed, we have experienced that in practice.
Okay. Well, Aji, if you want to respond to that, please feel free. I also want to add on some one additional question that's on the portal, which is someone has asked that if they have a company and maybe for a while they want to suspend their activities for economic reasons and then resume later on, is there a process for suspension of the company? I assume this person is concerned about not having to file annual returns and do all those things if they want to suspend company activities for a while. I don't know if it's possible. I would appreciate if you could comment on that.
Thank you. I will start with the first question on update. I think the sheer number of companies, with the sheer number of companies, it will not be possible to start from company number one to the last. So that's why we have to prioritize those that request for this update. We update them as they come. We have over 5 million entities in our database as we speak. So you can imagine if you are going to take number one to the last, how many years will it take you? How many are we? We're only 1,260 or thereabout. So we are prioritizing, and for the first time, at a glance now, you will know whether a company is active or inactive. And the way we determine active is companies that are up to date in their regulatory filings. This is forcing a lot of companies to come out and update their returns. And I can assure you, for any company that is classified as active, that company's status is up to date. The record is updated, and we don't have any issue with that company. So I have mentioned this, it behoves us as company secretaries or as legal practitioners to request for this update. We have a team of over 100 people that are doing this on a daily basis. The difference between updates and normal approvals is, whereas normal approvals, we can do it from the comfort of your home at any time, even on weekends. Update, you have to be in the office physically, because we won't allow you to move our files to your house. And sometimes beyond updating the database, some of these documents have to be scanned and uploaded. So we are adding more people to the team, but we are also concerned about the quality of what is being updated. We don't want a situation where customers will begin to complain that, look, there are spelling mistakes, some of the dates entered are not correct, and what have you. But with time, all these things will become history. Particularly when you compare the name of the number of active companies as against those that are inactive. And we are also prioritizing according to sectors, because companies that are under regulatory purview, either of the SEC or PENCOM or CBN, these are companies that are actually going concerns and they're in serious business. So these are companies that are up to date. So we are prioritizing. We have a team dedicated to updating this record. And it's not just the update. We have significant number of business names that have not even been captured in the database yet, because hitherto the process of registration was decentralized and it was manual. And there was no deliberate policy then to actually capture these business names. A lot of business names, if you check the database, you won't find them. So we have created a middleware application that allows the state offices to capture these names. And the details, as they capture, then we integrate it to the application. On temporary suspension, the law has provided for voluntary striking off, so they can take advantage of that provision. But if while you are doing this, it's just for you not to file annual returns, I don't know whether that will save you. And I doubt if you apply to strike off voluntarily, whether you are at liberty to come back and continue with your business. So you have to make a choice. If you are simply filing returns, you can still file new returns. If you are filing your return as and when due, the money is not much. You just pay 5,000 naira a year, and that will secure the name of your company for as long as you continue paying. And the law has also made the process of striking off more stringent now. You have to wait for 5 years. You have to have evidence of inactivity for 5 years before you could strike off. Unlike before, where it was more or less subjective. The law says if the CAC has reasonable cause to believe that a company is not carrying on business or in operation, it can strike off the name after sending letters to the company. The process has been made more stringent, and I think it's Osofo and others that actually smuggle those provisions to actually tie our hands. So you can take advantage, just file the returns, even when you are not doing anything. That will actually secure the name for you, because if you allow it to be struck off, I don't know, you may not be in a position to come back easily. Thank you so much.
Thank you, RG. One very useful comment that has been put up in relation to the proposed customer forum that you intend to host is that if you allow virtual participation, then more people will be able to take advantage of it. So I don't know whether you want to consider maybe doing a hybrid where people can also log in, at least benefit from the order that's going to be discussed.
Well, I'll give that task to you as SBR. If you can look at that option, you have a robust technology. I'm doing it out of my base, so I may not be in a position to make that arrangement, but SBL can actually look at that, and that will be useful. At least people can participate virtually.
Yes.
Okay.
Thank you. We will take up that challenge. I think that our time is almost used up. We've tried to get through most of the questions. Some of the questions, if we've not gotten to your question, we're hoping that those are the sorts of issues that will be addressed in the customer forum that we've mentioned, and we will put out the information once it has been finalized with the CAC so that you can arrange to attend either physically or virtually. I'm going to go around our panel now and just ask for a final word before we round up. So if I could go to Ms. Longe, final word from you on behalf of the SMEs and startups. You're muted.
Thank you. Sorry. Thank you very much. I'd like to say first, thank you to the RG for being here and for the collaborative approach, and responses. I'd also like to say thank you to the NESG and the organizers. This kind of conversations are necessary so that everybody's position is taken into view. But on a general note, I will commend the CAC for the improvements and the continuous commitments to making things improve. And I look forward to these new initiatives. The RG has mentioned a number of things that are going to be, implemented on the application. So I look forward to being able to use this, and so that more small businesses can continue to, more people can start their businesses and operate their businesses. Yeah.
Thank you very much. Ms. Adeyemi, final word from you.
Thank you very much. Thank you very much, Osofo. Just two things I would like to say. I mentioned the issue of the company secretaries earlier on, and I just wanted to make this observation that interestingly, we actually had an upsurge in the request, to act in that stead, in that position, for even small companies as well. So just to reiterate what the RG said, we shouldn't bother ourselves with some of the smaller things. At the end of the day, the investing public will know what that which matters to them, and they know that they cannot do without professionals in the long run. But more importantly, I honestly want to commend the RG. He has provided significantly, he's provided leadership to the CAC, and there has been remarkable turnaround. You can see, and this has happened at the time when significant transition is being made. You're going from virtually, manual, to full, almost full automation. It's no mean feat. And sometimes, I see the speed of response, particularly when as company secretaries, we're seeking approval to hold virtual hybrid AGMs for public companies, sometimes in the middle of the night, and you see an email come from him. The speed of response has been very encouraging. I commend what he's doing at the CAC, and I ask that he should just take all of this feedback, on those small minor areas that still require work to be done. Particularly also, I like to say, with training and upskilling the staff, sometimes it's a question of them not even understanding the regulations themselves, or sometimes also not understanding the business that they are helping or seeking to register. But also, I think it's a wonderful job that he's doing, and I ask him to continue in that state. Thank you very much.
Thank you. And final word from the RG.
Well, I don't know what to say. I just want to thank the NESG for the opportunity. It's always a delight to be part of such interactions, and I will thank my co-panelists. We've taken the feedback. I just want to assure all our stakeholders that this is not a one-off thing. They will continue to notice continuous improvement. We'll not rest on our horse until we make sure that our registry is comparable to the best in the world. Thank you so much. Thank you.
Thank you, sir. Okay, so on behalf of NASBA, the NESG, which hosts the NASBA Secretariat, would like to thank all our panelists, our three panelists today.
So the way I want to look at it is that there's a short-term solution and there's a longer-term solution.
That's participant. Thank you. So we want to thank you all for your time and your expertise shared today. I think the vibrant Q&A chat that we had showed the interest of participants. I think the discussion was very stimulating, and it led to a lot of inquiries, and we look forward to participating with you on more discussions of this nature in the future. I'd like to also thank our participants that have stayed for the 2 hours of this program. We appreciate your time, and we also appreciate your level of participation. It's been very interesting, the comments that have been made, and the even recommendations that have been made on the Q&A platform. Thank you also to the team working at the back to make this possible. So that's it from me. Thank you, everyone. If there's nothing else from NESG, I think we've come to the end of our program. Thank you.
Thank you very much.
Thank you.
Thank you. Thank you, madam. Bye.
Thank you. Bye-bye.
Thank you. Bye. Thank you.
Bye.